I have been in this job since April 14th, and prior to that, the previous 6 months, I was the Assistant Secretary for Programs for DCF. During that time is when Alan called and said, I don't know, it was Alan or whoever called and said, would you do the legislative update? Because Alan saw me, I saw Alan almost every day in Tallahassee during the sessions for one reason or another. So I was deeply involved in everything that happened, but I was wearing a DCF hat during that time. And I want to say this going into this presentation because now I have another hat. And people have said, oh, now you're on the dark side. Or if you're on the CBC world, you say, well, now you've got a white hat. And I will tell you that watching this session this year, watching DCF and the CBCs not be on the same page was not a good thing. Okay? So going forward, this year, we have a meeting next week. We meeting the CBC CEOs and Secretary Carroll are meeting next Thursday. One of the main things I know we are going to talk about is starting next week, if we haven't already started, working together so that the legislature doesn't get 10 different versions of what goes on in our system, and then you end up with legislation that we have. Because there's some stuff in this legislation that I think almost everybody goes, what? When the session started, there was the hearing in Broward County, the public hearing that Senator Sobel held with Esther Jacobo, who had just taken the job as the interim secretary. There was lots of stakeholders who were involved in that. But that was the beginning of the charge that Senator Sobel had to do something about all these dead kids. Basically, she was told by the Senate President, you will pass some legislation that does something to keep kids from dying. And so as the session started to move forward, that was her question every time. What are we going to do? How does this keep kids from dying? Whatever it is that somebody proposes. And so I will challenge you, when you look at Senate Bill 1666, as you go through that, you tell me what in there is going to keep kids from dying. Okay? It's hard through legislation to do something that's definitely going to reduce death. We all want that to happen. I don't think there's anybody that wants kids to die. I mean, that's ridiculous. We all know kids are going to die. So the question is, how do we do that? What ended up happening, and you'll see it in Senate Bill 66, is that there's all kinds of administrative things. There's some changes to 39 that happened. There's some good things in there, but there's all this bureaucratic administrative stuff. Okay? I can say that being a CEO. I'd say it if I were still the Assistant Secretary for DCF. If anything, DCF got a whole lot more than the CBC's got. Who in here is an attorney? Goodness. Who's not an attorney? If you're not a lawyer, raise your hand. Anybody in here CBC related? Okay. Anybody in here DCF related, not a lawyer? How about attorney generals or parents' attorneys? I don't. OAG? Yep, okay. Do you disagree with me if you've read this bill as to what's happened here and what we have to do going forward? Because absolutely, we cannot start even next month and continue to have DCF and the CBCs doing this. We just cannot do that. We do not get good outcomes when we do it. All right, that's my prayer for the day. Hopefully this is going to work. Okay, these are the bills we're going to talk about. We're going to do Senate Bill 1666 last, because that's the doozy of them all. So we're going to talk about 561, Attorneys for Dependent Children with Special Needs, 977 is Peace, Independence, 989 Human Trafficking. There's 2 human trafficking bills. House Bill 741, Human Trafficking, is the bigger House bill on human trafficking. What's really interesting about that bill is at the end of it, there's a section, I think it's section 11, that has the proviso language for Senate Bill 1666. It says at the end of it, and this happened with just a couple of days to go in the session, oh, by the way, you passed Senate Bill 1666, and here's the money for the non-relative caregivers and other things. That's the craziest thing, and that's indicative of what was taking place in Tallahassee with the child welfare we were going through. Can you see this? Because I know it's kind of like, can you see it? And I did not turn this in ahead of time. I finished it last night. Can you see it, Bill? Okay, we're good. And let me apologize, first of all. Normally when I do a presentation, I spend more time making it pretty. I was just in Robin Jensen's session, and she had music and flying stuff and all this stuff. I at least usually put some nice pictures of kids, but I didn't have time to do that. I got the content, but I don't have all the frills, so I apologize. Hopefully there's no typos. All right, so 561 61, attorneys for dependent children with special needs. Over the last couple of years, Alan went somewhere else, right? There's been a real push within the state to have lawyers for all kids in dependency, not just the narrow class of children that we're going to see in this bill. But there, in many states in the country, kids in the dependency system, they get their own attorney as a matter of course, as part of their process. We got close to that a couple of years ago. The Legal Needs of Children Committee, I think, actually advocated for it. And then there was some pushback and some politics got into it and it didn't happen. I know when I was still with CLS, we have lawyers for kids that are filing saying it's a constitutional right for a child to have an attorney. Child's incompetent as a matter of law, they're a party. Usually incompetent people get lawyers, but anyway, we don't do it. So now we've got this done. So 39.01305 is a new statute. If an attorney is available who's willing to represent a child without additional compensation, then you appoint them. So if they're already there. So if they'll do it for free, sign them up. That's what that says. An appointment must be in writing and continue until the attorney is allowed to withdraw as discharged by the court or the case is dismissed. So if you sign up, you're in it till the end. Okay? Whoops. They're appointed for Chapter 39 as well as in fair hearings and appellate proceedings. So it's not just the dependency case. Okay? So if they've got an independent living issue or something else that they need to address, and you're their lawyer, you get to do that too. Medical and related needs, services necessary for the child to live successfully in the community. Funding provided for this representation is not to replace proven existing organizations representing children. As the bill was going through, somebody pointed out to the legislature, well, what about in Palm Beach County where we have the, what's the name of the entity that does the representation there?
Legal Aid Society.
Legal Aid Society. We don't want to replace them. We don't want to replace those areas in the state where we have a proven model for kids being represented, so we very clearly say this is not meant to take that away. It also says that if they're in appellate proceedings, that the attorney can get somebody else to do that piece for them. So even though they signed up to go through the end, they can get an appeal for you to come in and do that piece. So here's how dependent child is defined under this section. So the question is, does that definition apply to the rest of the chapter? I would say no, and you'll see why. Dependent child in this section means a child who is subject to any proceeding under 39 and does not have to be adjudicated dependent. You can get a lawyer from the get-go. Shelter hearing. You need an attorney. The attorney is appointed for a dependent child too, and these are the categories that you're looking at, and it's in the statute. It's an or list, so it's any of these. So resides in a skilled nursing facility or is being considered for placement in a skilled nursing home. Is prescribed a psychotropic medication, but declines to assent to the psychotropic medication. So if they're on psychotropics and they say, I don't want to take them, give them a lawyer. Has a diagnosis of a developmental disability as defined in 393.063, is being placed in a residential treatment center or being considered for placement in a residential treatment center. That's really 39.407. We kind of have that now, but it's expressly in here now. So being considered, what's that mean? Okay, so you're saying the interpretation is do a suitability assessment, they get an attorney at that point, not when it comes back and says, okay, we want to put them in, right? That's the Natalie interpretation of the statute. So we'll go with that. You got a different view, Kate? Yeah, I think you could argue as soon as you start talking about it. So the case manager says, wow, this kid needs to be in residential treatment. They're being considered. I want to get them an attorney. I get what you're coming from. All right, the victim of human trafficking is defined in 787.062. Why do they need a lawyer? What else was going on in the session this year that we'll talk about? Confidentiality, special needs, criminal cases typically, if they've gotten charged in human trafficking, where they're being subpoenaed to come in and testify against somebody, probably want a lawyer for that, especially if it's turning into a child that's being dependent. All right. Before appointment, the court has to request a recommendation from the guardian ad litem office. So here we are at the Guardian Disability Conference for an attorney who is willing to represent a child without compensation. So the judge says, gee, yeah, we got anybody that's going to do it for free? If they're available within 15 days, the court has to appoint that attorney. The court can appoint a compensated attorney within the 15 days if the guardian ad litem office says that they won't be able to recommend an attorney within that time period. So if the judge says, GAL, we got a free attorney, they get 15 days. If the GAL says, we can't tell you in 15 days, judge, they get a lawyer. You don't wait. Okay? Who asks? Who makes the request of the court? CLS should. Who else? Anybody. Everybody has this statute. It doesn't expressly say. I would think it's incumbent upon CLS, but I think anybody in the case. Except if the attorneys agree to provide pro bono services, the attorney organization must be adequately compensated. And we'll see if you think this is adequate. And provided with access to funding, for expert witnesses, depositions, and other costs of litigation. So it's going to come out of the Justice Administration Commission, just like the regional counsel does. They have to contract with attorneys appointed by the court, and attorney fees may not exceed $1,000 per child per year. Y'all going to run out and sign up to bid this lawyer tomorrow, right? Yes?
I have a question. If we are taking a case as a pro bono attorney, but there's something that maybe we need to do to assist the child.
You should turn in your request to the court, get the JAC to approve it, and get it paid. So if you need expert witnesses, deposition stuff, you should get that paid. You shouldn't have to pay that out.
The JAC would just come in then once you ask the court to determine that, obviously they're indigent, but you would just have to do it as if it's a criminal case and get a determination of indigency.
I think that's the intent of what this is saying. So just meaning, if you're free, you still get provided access to funding for expert witnesses, etc. I think that's what that says. Okay? Department shall develop procedures to identify a dependent child who has a special need under those criteria that we just looked at. So develop procedures. Is that a rule? Having been in charge of rulemaking for a period of time there, I don't think that means a rule, but I'm not sure what it means. Probably means CLS needs to come up with something that says, here's how we're going to go about it. Maybe a rule of court. All right, so the department has rulemaking authority, so that probably answers that question. The statute doesn't limit appointment of an attorney for anything else. So there's lots of other reasons a judge may want to appoint an attorney ad litem in 39. This is not the only thing you can do. Okay? Starts July 1st. Everybody ready? You good? You got this? All right, one bill down. 977, Keys to Independence. Thank you to the Guardian Lighter Program for getting this law passed. Thank you, Alan Abramowitz, and whoever else lobbied and wrote this and got it through. Great deal. So the goal is to remove barriers for children in licensed care from being able to get a driver's license and motor vehicle insurance. I think the stats were like 3% of the kids in care get a driver's license. Who knows? Mary Kay, where'd you get it? Do you know that 3% of the kids in care have it?
Yeah, I think it's
like that.
lower than that.
Department to contract with a not-for-profit entity specializing in children aging out of care to establish a statewide pilot program to pay specified costs of driver's ed, obtaining a driver's license, and motor vehicle insurance on a first-come, first-served basis. $800,000. You're going to see it's one of the bullets later. $800,000 was allocated for this. I got an email driving down here this morning from Alan Abramowitz through his brother as the Northeast Region Director saying, hey, we're going to come talk to you. Let's get some kids because we want to spend this money. And Alan came up right before and said, we got to spend this $800,000. We got to get it done. So we got to sign up kids because if they're going to take driver's ed, many of them are going to take it this summer. Get them signed up. He was saying potentially, and this is not a promise, but the Boys Ranch is saying, bring them all up for 3 days, we'll do it. So you can spend some of that $800,000 if that works. But it's first come, first served. So if you got kids that are wanting to get their learner's permits, sign them up. Department has to submit an annual report including the recommendation of whether to keep going. DCF, more work. Give us a report. Preferential enrollment in driver's ed for specified children in care. Have to keep appropriate progress in school. So dependent kids go to the front of the line for driver's ed. It amends 947.43.047, which is the disability of non-age, so that kids in out-of-home care 16 or older can sign motor vehicle insurance paperwork. So they can go down to Allstate and go, here I am, I'm 16, here's my court order, I need insurance because here's my driver's license. That's pretty impressive, I think. $800,000 in recurring funds, so it'll be $800,000 again next year. If that report says, let's do it, and the legislature says, yeah, this is a good idea, let's keep doing it. Great bill, isn't it? Third bill, Human Trafficking Victims' Rights, House Bill 989. It amends Florida Statute 92.56 to allow the use of the pseudonym for a victim of human trafficking in discovery. That's for criminal cases. Why is that in there?
Retribution against families, them.
Families and victims, yes, exactly. So that trafficker may not necessarily be able to find her in terms of discovery when you're starting to go through that. Prohibits identification of human trafficking victims in media reports, just like victims of sexual abuse. Good things. Provides that, and I just shortened it to HT. HT victims are eligible for crime victim compensation awards and relocation awards. Increases the penalties for the human trafficking offenses. This bill is 123 pages long, I think. 80 of it is all the criminal statutes bumping up the penalties. So if you pull the bill and you go, oh my God, I'll never read all this, you can read it. It's not that long as far as the section. Provides for expunging of criminal arrest or court records where the victim of trafficking may have been charged with the crime as a result of being trafficked. So many human trafficking victims come to the attention of the system because they get arrested, and you'd think it would be for prostitution. I think the majority of them are not for prostitution, for like petty theft and other things like that. But that's what ultimately is determined is they're being trafficked. And so if that's happened and they are getting arrested and they're getting charged, and they can show the victims of trafficking, they can get their criminal records expunged. And then it says it requires destruction of investigative records related to the expunged records. Why do we do that? Any victim advocates? Come on, you GAL folks. You've got a child who's a human trafficking victim on your caseload. Why would that be a good thing for her? Okay.
I think it's because they're under 18 and you want to expunge their juvenile record and get rid of all the investigative things so they don't bring it back later.
Right. Did you hear that?
There's exceptions to expungement rules that allow certain agencies and for certain purposes to go back behind the records. The rest is that.
I mean, the logic behind it is I'm not sure it's limited, I have to look at it, I'm not sure it's limited to just minors. You can be trafficked and be over 18. But I think it's exactly what Tom said, and that is that they're committing these crimes because they are victims themselves. This is the shift that we're trying to get through in the state in terms of human trafficking, is not to treat them as criminals. One of the most derogatory terms I've heard in the human trafficking world is referring to these victims as prostitutes. That's insane. So that's the way people think. Oh, here they come. Here comes your little prostitute. She's in your office. Go talk to her. She is a victim. A 14-year-old who is having sex with a 20-year-old is being raped. She gets arrested for prostitution. This is what happens in our world. It's insane. So we want to do what we can to erase their history of having been a victim, having done things that got criminal records created because of having been trafficked. Get rid of it completely. Destroy it. So just like Tom said, it's not there for the FBI to find when she wants to get in the military. Okay? Prohibits the employment of minors in adult theaters. As the session was happening, every day if you work for DCF and you ask, you get the news clips. Anything around the state where the DCF is mentioned pops across your screen. There was a topless bar, adult theater, down in Broward County, and they had a girl who was 14. The manager was out of town, he said, when this girl came through. Told the guy who was running the place at the time, I'm 20. Okay, good. You start tomorrow night. She comes in with a fake ID. I hire her. She's 14. She's being trafficked. So they had to tighten up the laws and say, you can't do that. You have to get adequate identification. And I didn't go through this. But that's in the statute as far as what the adult theaters have to do to prove that the people that work there are over 18. You can't just walk in with that fake ID and get it done. Makes it a second-degree felony to permanently brand a victim. Again, if you haven't been through human trafficking training, you will be disgusted by what the traffickers do to their victims. They tattoo their name across their lips or over their eyes or wherever it may be. They brand them so that the other pimps don't take them. That's my girl. See, my name's on the list. Permanent branding means a mark on the victim's body that can only be repaired or removed, if at all, by surgery, laser treatment, or some other medical procedure. So just the branding gets you a second-degree felony. Eliminates statute of limitations for prosecutions of specified human trafficking provisions. That's a good thing. She may not come forward until she's 25 or 26 and says, guess what happened to me when I was 14 and 15. I got out of it, but I want to go after the government. That's effective date is October 1st. What's that?
What was the first one effect?
The first two were July 1st. This is October 1st. All right, human trafficking. This is the bigger human trafficking bill. This was the most controversial bill, I think, that I got to have the pleasure of appearing a couple of times regarding. Because we started out, and I give full credit to Representative Gail Harrell, because she took this on early. They took it on last year, so the the last 2 or 3 years. The human trafficking bill that came out 2 years ago, they created the safe houses, and they gave money last year for some pilot programs to try to create safe houses. She had informational sessions where they brought in people from around the country that specialize in providing treatment to human trafficking victims. There's a place called Wellspring up in rural Georgia that was really the best example of how they treat human trafficking victims. And it's the closest of what you would call a secure facility, which is the euphemism for lockup. It's not a lockup, because if you go, and she's very explicit, they go and they push on the door, it doesn't open right away, it sets off an alarm, and it gives the staff a few seconds to run down there and say, wait, you don't want to leave, and then it'll open. So if they can get and hold it long enough, they can go, which keeps it from being a lockup. It's also out in the middle of nowhere. So if she goes and pushes on that door, there's nothing. So as we were working on this and saying, we want to take it a step further. The reason we want to take it a step further is because many of these victims, and you'll hear about this in Miami and Broward County particularly, is where the stories were coming from, the anecdotes. They get picked up by law enforcement. The law says, nope, they're dependent if you don't have a caregiver, so take them to DCF. Take them to DCF, out the door, back to the pen. Even if you get to keep them for a little while, they come into care. He finds her. Whatever home she's in, she's texting, whatever. They connect up. She goes out the door, down the street, back in the car, back to the streets, back to being a victim, having the life that they ultimately have, which is not good. So, there are those who believe that for a certain very small subset of human trafficking victims, we should keep them in a secure facility so that we can break that cycle, break that bond between the trafficker and the victim. There are many people who think, no, you are doing exactly what the pimp tells you. If you talk to law enforcement, you're going to jail. So putting them in a secure facility just reaffirms what the pimp told them. You're putting them in jail. You can't lock these girls up. That's inhuman. It's unconstitutional. So again, in my job in the last 6 months, I was able to make suggestions on the language to try to make it constitutional, because I think it can be, and I'm not saying we should do this, because I know people think it's horrible, but I think it can be analogized to a baker or residential treatment under 407. If they have a need to be in there and you can demonstrate it, it's there. So it started out in the bill, lots of hearings, taken out of the bill. So the idea of safe, secure, and separate placements is still in there, but the lockup, if you want to call it, is not there. So when you go through this bill, you'll see just about everything except that. That was taken out. The politics was very interesting. We'll talk about that later. All right. I do remember vividly, though, being asked in the hearing, Mr. Pennypacker, what do you think of this? And I said, well, I think it's something about which reasonable people can differ. I went outside, and I got attacked. Somebody later came and said, can I see those scratch marks on your back? All right. Requires specialized intensive training of child protective investigators and case managers who handle cases involving the sexually exploited child. So we have to have them, and we have to assign those cases to those CPIs and case managers. Mr. CBC CEO, I got 3 case management agencies. Where am I going to get my sexually specialized intensive training for protective case managers for me, but CPIs? When's that training going to start? When are they going to be on the street? Am I going to have them when the law goes into effect? Because believe it or not, we have trafficking in north central Florida where I work. It's everywhere, you just need to be looking for it. I'm sure you got girls in every county. If you start looking at the criteria, you'll figure it out if they're being trafficked. All right, so the department, as the lead agency and other community stakeholders, has to assess the service needs and system gaps, drafting local protocols and procedures that allow for a response that is specific to the needs of the sexually exploited child. That's a local protocol. Amend Order 1678 to define and identify safe house and safe foster home, to include creating a certification process that must go hand in hand with the existing licensing process in order to self-identify as a safe house or a safe foster home. So if you identified a human trafficking victim, they need to go into a safe house or a safe foster home. Safe house meaning group care, safe foster home meaning a foster parent who says, I'll take them. Got to have a special license to be able to do that special training. Screening of child, consider a minimum of the following factors. The risk of the child running away, risk of the child recruiting other children into the commercial sex trade. When human trafficking victims were brought in, this was happening, and I'm sure it's still happening, they're coming to that group home. Wow, look at all these girls I can recruit for my camp. And I can get off the bottom of the ladder. If I get one or two of these girls to work for him, maybe I'll get off the street. That's what they do. Level of the child's attachment to his or her exploiter, level and type of trauma the child has endured, nature of the child's interactions with law enforcement, are they cooperative, length of time the child was sexually exploited, and the extent of any substance abuse by the child. Again, the horror stories. Girl walking down the sidewalk, dragged into a van, drugged, raped, put on the street 2 days later. Not the girl in middle school that's shy and he meets her in the mall and, woos her and, oh, you're my baby, you're my girlfriend, takes her shopping, really nice to her, then rapes her, then does that, puts her on the street, right off the street. It's happening. They can make $200,000 or $300,000 per girl per year. So if she can recruit a couple out of the group home, good for him, good for her. Human trafficking. The department will specify the contents of training for foster parents who wish to stay foster home, lead agency will ensure the foster parents completed the appropriate training. So that's our job. The department will be responsible for inspecting the safe houses and safe foster homes prior to certification and annually thereafter. Residential treatment centers under 394 have to provide specialized training for sexually exploited children in the custody department who are placed in these facilities. Now,
Can I go back to the screening piece real quick? What are we contemplating? Who's going to be doing the screening? Who's creating the screening?
good question. The bill has some requirements that the screening, and again, there was so much that I could have talked about, and I'm keeping conscious of the time because there's so much. I would say read the bill because it talks about the department requiring getting together with a bunch of expert people to come up with a screening tool and to have that be able to be used around the state. These are the criteria that the legislature says we want you to put this in the tool somewhere because we think these are the things that are triggers or red flags to a girl being trafficked. So who's going to do it? Figured out DCF, but DCF with everybody else. So typically it's going to be the investigator, law enforcement. DJJ needs to be in the middle of this because a lot of these girls come to the attention of DJJ before we ever got them. So they need to do that. So what I would say is, and I know it's an offhand answer, read the bill. Yeah, that's a good question. It is explained much better. It's about 4 pages. The department responsible for inspecting said that. All right, develop a statewide council on human trafficking to include the department with the goals of developing recommendations for comprehensive programs and services for victims of human trafficking, to include recommendations for certification criteria for safe houses and safe foster homes, as well as work with the department to create and maintain an inventory of human trafficking programs and services in each county. So again, give credit to Representative Carroll, the House Healthy Families Committee. They are not giving up on this. This bill moves the needle that much further down the road. They want us to figure out the best way to handle this because, again, when you start seeing what's going on here, you will be as motivated as they are or more to try to do something about it because it's a very difficult problem. Each region, department, and each community-based care lead agency establish local protocols, procedures for working with sexually exploited children, which are responsive to the individual needs, etc. Department shall assist circuits to obtain available funds. I'm looking forward to that. For the purpose of conducting law enforcement training from the Office of Juvenile Justice and Delinquency Prevention of the United States Department of Justice. So the legislature thinks there's some money in that federal Office of Juvenile Justice and the U.S. Department of Justice. Who's here? Is anybody here from the DCF Central Office? OPAGA has to conduct an annual study on commercial sexual exploitation of children in the state that shall analyze the effectiveness of safe houses, safe foster homes, residential treatment, and hospitals with specialized programs for sexually exploited children and other residential options, addressing their safety, therapeutic needs, educational, emotional needs. So they don't want DCF writing this report. They want the independent to apply it. Tell us how this is going, and I'm sure tell us what to do about it in addition to that policy council that was created. Again, working with the legislature, trying to bring, if you've ever spent time, let's see, let me go backwards a little bit. Tom Daniel, how long have you been working in the dependency arena?
1997.
97? 87. 85. So you precede the Adoptions and Safe Families Act of 1997, right? Anybody longer than that that's willing to admit it? Okay. Is Chapter 39 not a mishmash because it has been amended every year, piecemeal, this, that, and the other?
We reinvented it about every 4 years.
Yeah. So if you go through it, it still says this, and I politely suggested we don't have circuit administrators anymore. It didn't come out. They caught it in a lot of places. The word district, I think, is now pretty much gone from 39. I'm sure it's still in there in some places where we didn't catch it. So, circuit administrators, or their designees. If there's no circuit administrator, who's their designee? Right. Brian, are you a circuit administrator? Sure. Okay. Chief Probation Officer is the DJJ, and the Chief Operating Officer is the CDC or their designees. I'll be designated.
See, that'll be you.
Yes. Shall participate in any task force, committee, council, advisory group, coalition, or other entity in their service area that is involved in coordinating responses to address human trafficking or sexual exploitation of children. If such an entity does not exist, the circuit administrator for the perhaps an area of the statute that might be looked at next year. But you can see what they're trying to do. They're basically saying everybody that has anything to do with these kids in any way, get together and figure this out from the ground up, from the top down. Lead agencies shall ensure that all sexually exploited children residing in safe houses or safe foster homes or served in residential treatment centers or hospitals have a case manager and a case plan. This is the one CEO, whether or not the child is a dependent child. Okay, how do we do that? To the extent possible, provided by law with authorized funding, at least the services specified in this section may be available to all sexually exploited children, whether such services are accessed voluntarily, as a condition of probation, through diversion, through 39, or through referral from a local community-based care or social service agency. So if a girl shows up and says, I'm being trafficked, gotta help her. Can't just call a hotline and say, okay, now we'll take her that way.
Is that going to lead over into the delinquency realm? So if you have a kid who goes into delinquency court and says that she's a victim of HT, we're now providing her a case plan. We're providing how, or not necessarily only if she's
Correct. So when she comes to DJJ, first of all, she should be getting out of DJJ and coming over to dependency if her charges are related to something as a result of being trafficked. Well, it's interesting because I was in, where was I? I was in San Diego. I went to the National ICPC meeting again, and they had a judge there from Los Angeles who does all the trafficking cases. And she does them all because she does the criminal cases. So she has a specialized court to help these trafficking victims. She still prosecutes them because that's how she locks them up for treatment. She keeps the criminal case going, so she can confine them. So she didn't have to deal with the constitutionality issues that we were dealing with this year. Anyway, I thought it was interesting. So to answer your question, Stacey, yes, I think get them out of EJJ, get them into this kind of The department shall contract with a qualified consultant or organization with expertise in child welfare by August 31st to prepare a plan for development and implementation of a comprehensive results-oriented accountability program consistent with this section. So I think Judge Sean DeGarria was hired to implement all of the new legislation for DCF. So that will be her job to find that expert along with lots of other things. Effective date July 1st. So, you got a human trafficking victim, shows up at a shelter hearing. What are you going to do differently on July 1st or 2nd? I think July 1st, that's a Monday? The 4th is a Friday? What are you going to do differently? What's that? Placement. Where are you going to place them? Safe house? Yeah. Safe foster home? What else should you be trying to do? Raise your hand so I can hear a lot of mumbling. Raise your hand so we can call on you. Okay.
Make sure we don't have any criminal charges. If they do, you gotta go talk to the prosecutor.
Okay. What else? Paul.
Have an attorney appointed.
Yay! You win. If I had chocolate, I would throw it to you. Remember the last criteria on that attorneys for dependent children? Victim of human trafficking. Very good. Thank you very much. I met Paul for the first time Saturday. All right. Senate Bill 1666. See how we're doing on time. Creates an assistant secretary for child welfare who is appointed for this by the secretary, must have at least 7 years experience working in child protection and child welfare. One of the main issues in the session this year was CPI should have to have social work degrees. When this bill started out, it said assistant secretary 7 years and a master's in social work. That got taken out. I was angling for that job and was glad that got taken out. I don't have a master's in social work, but so now that will be there, and I don't know what the department is doing. I kind of wish somebody in the central office here. Pat, do you know what you guys are going to do with this?
Which one?
The first one, assistant secretary for child welfare. Is there going to be an opening and people apply, or is somebody going to be appointed to that? Has it already happened?
It is an appointment. It will be an appointment, and I don't know whether or not there will be an application process for assistance in appointment.
Okay. It'll be interesting to see how well that plays out. Expands the definition of diligent efforts by a parent. And I apologize for not putting all the statutory sites in here again. I would normally have done that for you and had some less but you'll find it. It's in the definitions in 3901. Look at the D's, you'll find it. To include the requirement of a meaningful change in the behavior of a parent that reduces risk to the child. Why do you think that's in there? Why did the legislature put that in? I'll help you a little bit. In terms of what they got from input, there was a lot of input that was done in the formal hearing process where they put you in front of the committee and you come in and you actually don't have to raise your hand to testify, you just start talking. But a lot of input comes behind closed doors. A lot of complaining about how things work and why cases don't work well from various stakeholders all throughout the system. So given that, what do you think people were complaining about in terms of adding that to the definition? Meaningful change in the behavior of a parent.
How do you know?
Yeah, you want some kind of measurement to say, what are diligent efforts? So when you start talking about substantial compliance, well, okay, they did diligent efforts. They tried real hard. That's a diligent effort. They didn't make any change in their behavior. Then will count, right? All right, creates a definition of present danger, impending danger, and safety plan. I'm contemplating reading this to you. I think I will. Impending danger means a situation in which family behaviors, attitudes, motives, emotions, or situations pose a threat that may not be currently active, but that can be anticipated to become active and to have severe effects on a child at any time. So, impending danger. Who in here has taken any kind of training on safety methodology? Oh, good. So you know the difference between impending and present danger? It's in the statute now. So, come July 1st, we should start to use these terms, right? And doing assessments. All right. Present danger, since you guys have all been trained, I won't read that to you. Safety plan is in there. There's a long section in safety planning. I'm probably going to read that in terms of what the CPI has to do because I think it's really important. So let me get to that. We'll come back to medical neglect. Safety plan means a plan created to control present or impending danger using the least intrusive means appropriate to protect a child when a parent, caregiver, or legal custodian is unavailable, unwilling, or unable to do it. So do you do a safety plan when there's no present or impending danger?
No.
Are people doing that?
Yeah.
Yes, they are. While I'm on the S's, we'll see the later slide, I know it's jumping around a bit. Siblings. If you haven't heard, sibling is now defined to mean a child who shares a birth parent, a legal parent, with one or more other children. That's what most of us think of as a sibling, right? It's your brother or sister, got at least one parent in common. Or a child who has lived together in a family with one or more other children whom he or she identifies as siblings. No biological connection, but that's my brother, that's my sister, we've been raised together. Why is that important? Yeah, you're going to see when we get through some of this. They are really big on siblings staying together. There's lots of provisions all the way through the statute now. Okay. Bear with me on this, because I'm going to read to you. If the child protective investigator implements a safety plan, the plan must be specific, sufficient, feasible, and sustainable. Straight out of the methodology, right? At least the sufficient, feasible, and sustainable. In response to the realities of the present or impending danger. The safety plan may be an in-home plan or an out-of-home plan or a combination of both. The safety plan may include tasks or responsibilities for a parent, caregiver, or legal custodian. However, the safety plan may not rely on promissory commitments by the parent. I remember vividly testifying and explaining why that was not a good idea, and we did it all the time, and why we had a lot of dead kids because of that. Right, Pat? Promissory commitments by the parent, not in the safety plan. Caregiver, legal custodian is currently not able to protect the child or on services that are not available will not result in the safety of the child. The safety plan may not be implemented if for any reason the parent's guardian or legal custodian lacks the capacity or ability to comply with the plan. If the department is not able to develop a plan that is specific, sufficient, feasible, and sustainable, the department shall file a shelter petition. Okay? Present or impending danger, can't do a safety plan, removal. Is that consistent with the methodology? All answer at once? Yes? No? Yes. Yes, I think it is. Let's see. A child protective investigator shall implement separate safety plans. You're going to want to follow this. For the perpetrator of domestic violence and the parent who is a victim of domestic violence as defined in 741-28. If the perpetrator of domestic violence is not the parent, guardian, legal custodian of the child protective investigator shall seek issuance of an injunction by 39.504 to implement a safety plan for the perpetrator and impose any conditions to protect the child. Boyfriend's the batterer, you need a safety plan, you will get an injunction. You will seek an injunction under 39.504. How many attorneys in here have filed a petition for a 39.504 injunction? Yay. Good for you. The safety plan for the parent who is a victim of domestic violence may not be shared with the perpetrator. How are we going to keep that from happening? Joy, how are you going to implement that? You were chatting.
Yes.
Caught her off guard. Safety plan for the parent
We're
who's a
talking about
victim.
enforcement of 39.
Yeah. The safety plan for the parent who's a victim of domestic violence may not be shared with the perpetrator. How are you going to keep it from being shared?
Under seal.
Under seal? That's a good idea. If the party to a safety plan fails to comply with the safety plan resulting in the child being unsafe, the department shall file a shelter petition. The child protective investigator.
Started off as repentance.
Yeah, we're getting there. The child protective investigator shall collaborate with the community-based care lead agency in the development of the safety plan as necessary to ensure the safety plan is specific, sufficient, feasible, and sustainable. Child protective investigator shall identify services necessary for successful implementation of the safety plan. Child protective investigator, community-based care lead agency shall mobilize service resources to assist all parties in complying with the safety plan. Community-based care lead agency shall prioritize safety plan services to families who have multiple risk factors, including but not limited to 2 or more of the following. This is very prescriptive. And I'm reading this as a CEO going, oh boy. So, 2 or more of the following. The parental legal custodian is of young age. What's young age? The parental legal custodian or an adult currently living in or frequently visiting the home has a history of substance abuse, mental illness, or domestic violence. That's pretty much everybody. The parental legal custodian or adult currently living in or frequently visiting the home has been previously found to have physically or sexually abused a child. That's a good one. The parental legal custodian or adult currently living in or frequently visiting the home has been the subject of multiple allegations of reputable reports of abuse or neglect. The child is developmentally disabled or the child is 3 years of age or younger.
Steve, what's that criteria for again? I'm sorry.
This is for prioritizing safety plan services, meaning we know we're not going to have enough. These are the families that should get them in priority. Obviously, I think that's pretty much going to be everybody. Okay. So, sorry, I hope that wasn't too boring. Creates a statutory definition of medical neglect. Huge issue for the legislature this year, lots of testimony. The definition of medical neglect pretty much says if the parent is told by medical professionals, you need to take your kid to go get this treatment, whatever it may be, and they don't do it when they're capable of doing it, you got medical neglect. CPT, lots of advocates think DCF does a bad job of getting these kids into the system. Tom?
Do you have to show harm to the child? In other words, you should have gotten this because you did had this medical problem fester and become worse.
I'm going to read the definition now. Medical neglect means the failure to provide or the failure to allow needed care as recommended by a healthcare practitioner for the physical injury, illness, medical condition, or impairment, or the failure to seek timely and appropriate medical care for a serious health problem that a reasonable person would have recognized as requiring professional medical attention. Does that answer your question? No?
So if they got well on their own, it's not medical neglect?
If they got what on their own?
Yeah, if they got well on their own?
If they got well on their own, then there's no medical neglect. I wouldn't think there would be. Okay, so again, legislature very focused on this because we have like 200 kids that are in skilled nursing facilities. Many of those parents were not ever given really an option to get their kids home to provide the necessary treatment. They weren't told that was even an option. People think that's horrific, rightly so. So this is a way to start getting at it in terms of the dependency system. There's lots of other provisions in this bill related to medical neglect. I'm not going into them because they're separate. We talked about the definition of sibling, which now doesn't require a biological connection. Shelter orders have to contain findings that reasonable efforts were made to keep siblings together, including short-term group home placement necessary unless it's not in the best interest of the child. So the 2-year-old and the 17-year-old can't find a foster home, put them in a group home. Know what that means? Probably not, because that may not be in the best interest of the 2-year-old. Requires the department to provide recommendations to the court for sibling visitation if they are placed apart from the shelter hearing and justify any delays exceeding 72 hours. So if you come to a shelter hearing and you couldn't keep them together and it's going to be more than 3 days, what are you doing about it? Requires frequency, kind, and duration of sibling contacts for separated siblings as well as efforts to reunite them be included in JRs. There goes our template that we spent $10 million with IBM to put in the system. Spent another $10 million to put in a box that says sibling visitation. Creates a critical incident response team. Again, we got lots of dead kids. We don't think DCF's done a very good job figuring out why they died, or even after they spend all the months and months they do looking at it, doing anything to come back and change the system so that less kids die. Is that a fair summary, Pat, or am I overstating it?
If you read the cases of last year, 49 cases of child fatalities met qualifications that would lead to the need for rapid response.
Okay.
So it'll be a fourth layer of people looking at the cases that are already in that, quite frankly.
Okay. So again, the legislature responding to all the child deaths did this. Critical incident response team immediately investigates certain child deaths or other serious incidents. I don't think it defines serious incident. That'll be left up to the department. Identify the root causes and rapidly determine needed policy or practice changes. So go look. And Pat's saying it's 49 cases. Look at those 49 cases. And if you see something that we need to change, don't wait, change it. That's smart. At least 5 professionals with expertise in child protection, child welfare, and organizational management will be in that rapid response team. I hope they don't have anything else to do in their professional life. Because even if there's only 49 of them, they're going to be busy. Majority of the team must reside outside the judicial circuit where the incident occurred. Why is that? Bias, exactly. They think that people looking at these things are home cooking. Requires prompt posting on the department's website of any child death reported to the hotline. Any child death. To include the date of death, the allegations of the cause of death, the county the child resided in, not necessarily where they died, but where they lived, the name of the community-based care or case management agency involved with the family. Thank you, Partnership for Strong Families. Whether the family had been the subject of verified prior reports, and whether the child was younger than the age of 5. Okay? On the website, for all to see. Why did they do this?
Transparent,
Joy, why did you do that?
because they thought we were not being transparent.
Arkansas has a scrolling list of dead kids on their website, and they thought, oh, that's a great, go look at it. We want to do that. Started out with the child's name, all the identifying information, and that's any reported death. So law enforcement goes out to the apartment complex, 2 toddlers fell in the pool, drowned. They call the hotline. Put it on the website. Grandma was babysitting. She went to get a Coca-Cola. Kids got loose, got in the pool and drowned. We want the whole state to know.
What about constitutional rights to privacy or anything like that?
Well, there's no names. So the privacy is addressed. Pat?
And there's no time frame. It doesn't say you post that information within 24 or 48 hours either, but you're going to see something before July 1st. We already have a July 1st, like, you know, we're hoping to get it on June 1st, actually. Where you click on a county and it'll show you.
Secretary Carroll already appointed Lisa Rivera to be the new czar, I think was the word I read in the paper. All right, so they're going to be on the website. Here we go. Child CPIs to take steps if present or impending danger is identified, including the specific requirements regarding safety planning and prioritization. We just went through that. This one I think is critical. Voluntary services are not appropriate if there is a high likelihood of non-compliance, and that non-compliance would make the child unsafe. So putting back my DCF CLS hat on, does that require mandatory direct files then? God, I hope not, Trish said. I'm not sure.
What does high likelihood mean? And who's
What's high likelihood
threshold is
and
that?
who's going to decide what that means? But again, what they're trying to get at is, please don't give voluntary plans to people when risk is high and if they don't comply. So another methodology is going to result in high, very high risk assessment outcomes at the end of the investigation. Even with a safe child, this might kick in there for people to start arguing, oh, you got to take those to court anyway. I don't think so, but I just raised the question. Requires a dependency petition to include whether the parent has fully complied with a safety plan, and requires any safety plans to be provided to the court. And I can tell you from talking to judges about the methodology of safety plans, they're getting better. They have a long way to go. The judges are going to be educated. As this starts to roll out across the state, they're getting more educated, and they are going to be asking you in shelter hearings, what's your safety plan? And you, CLS, you, JL attorney, you, whoever's involved, better be able to answer the tough questions that I know are going to start coming in the next year from judges who get this and understand the difference between the safety plan and the case plan, and are going to start questioning what you did to plan for safety and what you're doing to follow up and who's really responsible. Adds compliance with the terms of the safety plan to parameters that may be required of domestic violence injunctions set by the court under Chapter 39. Kind of talk about that. So if you have a safety plan to address domestic violence and you go get your injunction, you got to put that safety plan in terms in the injunction. Adds non-relative caregivers to those eligible for financial assistance under the relative caregiver program.
You have a question about that, though.
When I was still the assistant secretary, I had a judge down in South Florida that ordered that, and so we all scrambled up to the general counsel and said, "Oh, we can't pay that." Now we'll be required.
It's not in the
Go ahead, what's your question?
How are we going to apply it to cases that have already closed? Are we going to?
I don't think you would argue this is retroactive. If you're a non-relative
There are
caregiver,
already ones that are.
if you're a non-relative caregiver and they want to come to court and say, "I know we closed supervision, but you still have jurisdiction, I want my money," and we'll get to litigate that.
We don't litigate that, Steve.
So how are you going to stop it?
Just say no.
Go ahead.
The relative caregiver program is sort of like past and aftercare and extended foster care, in that there's a whole administrative application and there's a fair hearing process if the department denies it. We should not be litigating those cases independently.
Somebody's going to litigate it then.
Well, somebody might try it, but we should stand up and object that there's no subject matter jurisdiction because it's exclusively an administrative matter.
Okay.
Well, I'm not litigating this.
That's okay. She just, Deborah's basically saying don't litigate it in dependency court, litigate it in administrative law court, right?
Right.
Okay.
I mean, Natalie is right, that yes, we're litigating something, but we're trying very hard to stay away from the substance. We're not going to litigate whether the department's going to give this person money. We're going to try to knock it out right away, and if we don't, we need to start doing whatever we need to do in the appellate court.
Okay. In the back of House Bill 7141, human trafficking, that's where they talked about the money for relative caregiver. If you want to go see, or not relative caregiver, if you want to go see how they did that little indirect. The department to be represented by attorneys. The department shall make recommendations to the court on issues before the court, and support its recommendations by testimony and evidence from witnesses, including sheriffs, CPIs, contracted employees, and subcontracted employees. This was a big issue for the legislature. There was a lot. The bill started out by saying the department attorneys will give deference to what the community-based care agency case managers want to have recommended to the court. This ultimately ended up being the language. There's some more language that goes along with this. There's a dispute resolution process that's required for that. So if you don't agree on what's best interest based on those recommendations, you got to go up there. Expands the parameters of William Wilson. It used to say if the child is enrolled in daycare, then they got to stay enrolled. Now it says they have to be enrolled if they're court ordered under protective supervision. The age limit is up to birth to school entry. So it's not 3 to 5. It's birth to school entry. If they're in DCF care, they've got to be in child care. As a CBC CEO, this one is causing me nightmares because ELC can't take all those kids. If they take all these kids, then all those other kids that are not in that category aren't getting ELC services because we don't have enough space. Stacey.
Is that, there's been some debate as to whether or not that includes, is that DCF care like foster care or DCF care relative, non-relative care?
Are under court order protective supervision or department custody. So to me, the or department custody means under court orders protective supervision means relative caregiver, non-relative, and that's reading system. Arguably, you could argue yes. But we're going to go to administrative court if we have to litigate. I'm sorry, no. All right, expands the grounds for TPR to include 2 new parameters. The child's been in care for 12 of the last 22 months without parent substantial compliance with the case plan. I'm not sure where that came out of, it just out of the blue. Does anybody know where that came from? Saw it there one day and go, where'd that come from? I think that's kind of the law now, but I don't know. The parent has been convicted of an offense requirement to register as a sexual predator. I think that is now 39806(1)N. So that's a new ground. And this is the one, I'm going to take some credit for this because I helped craft the language for this one because of the conflict between the DCAs on requiring a nexus when you have egregious abuse to one child and trying to get CPR on another child. This language specifically says that you don't have to have a nexus between that egregious abuse on one child to get a TPR on the other child. So hopefully the DCAs, where they required that. I thought it was in there for adjudications of dependency, but when I looked again last night, not there, so I don't know how that got from. Stay.
On sexual abuse cases, where you have the Supreme Court that's requiring the nexus, is the statute then going to trump that interpretation of the system?
I think the legislature trumps the court until they say.
Right, because this is a new law, so that'll trump that.
I think so. But we're going to litigate. Not in the All right, so that's the goal and hiring preference for CPIs and CPI supervisors to have a bachelor's or a master's in social work. And I was going to read you the long list of degrees, but we don't have time. It walks through it, and it basically says you need to hire these folks by July 2019. At least half of all CPIs and CPI supervisors should, and as a DCF employee, should is you're out, have this educational background. This bill started by saying within 4 years, all CPIs and CPI supervisors must have a degree in social work. 25% by the end of next year, 50 by 2 years from now, 75% 3 years from now, 4 years from now, everybody. That's where it started. This is livable, it gets the goal, I think this is okay. There's probably some people that still don't think that went far enough as to what it should be. This was one of the most contentious pieces of legislation, I think, or part of the legislation that came up. All right, so tuition exemption program for CPIs and CPs, child welfare personnel who want to get a postgraduate degree. So the statute says you go and you get 6 credit hours per term, and it's 40. For 5 years upon graduation, you have to keep working or you got to repay it. So you can't go get your graduate degree and quit the next day. You got to keep working or you got to pay it back. Student loan forgiveness program for child protection and child welfare personnel who have a master's in social work. So sorry, lawyers, you got to pay. Credit program employed by DCF and CBC or a subcontracted agency, $3,000 a year for 4 years. Again, you got to stay working for 5 years. You got to pay it back. The loan payments are made directly to the whoever's passed the loan, not to the person who's supposed to make the payment. You're paying directly to who they're supposed to pay. All attorneys employed by the department to receive training, dependency course, preparing and presenting child welfare cases, safety assessment, safety decision making, developing information presented to investigators and case managers for decision making, and experience in techniques of case managers and investigators, shadowing required of CPIs, and also I think case managers within 6 months of class. I did that already. 120 hearing. To challenge the CDC's decision not to recommend a home for licensing if a home has got a foster care license. Another cute little thing in the statute that says that's all well and good, but even if they get licensed, you don't have to put a kid in the home. So you deny them a license, they go, they win, they get their license. Don't put any kids in the home. That's the way I read it. Requires managed care plans serving children care to maintain complete medical, dental, behavioral health records and make them accessible to DCF and CDC lead agencies. Lead agency procurement. I don't think you guys are going to want to go through all this. Probably put me to sleep. I paid a lot of attention to this because it's important. The most interesting things I think are we have to post on our website now my salary. The COO and the CFO are their equivalents on the website. So if you want to know how much I make, I'll tell you if you come up afterwards, but it'll be up there. More than I make for DCF, I'll tell you that. Post on the website the 15th of each month the average caseload of case managers. So I asked the question, and we'll have to figure this out. Is that the day you posted? Is that the 30 days before you posted it before? What's that mean? The turnover rate for case managers and supervisors for the previous 12 months. The percentage of required home visits completed in the performance on outcome measures, required by 409.997 for the previous 12 months. for all to see. And I think, Pat, isn't the same thing for CPIs reporting, not on the website necessarily, but there's got to be a reporting that's done to the legislature on turnover and all that kind of stuff. Yeah, I think that's in there too. Community partnership matching grant, so you can get up to $500,000 one time for each lead agency if you can get $500,000 locally. It restores the risk pool. Again, in my new job, I'm very much concerned about these liability limits and insurance and all those kind of things. The damage limitations are now increased 5% annually, so that $1 million, $3 million will go up next year to $1,050,000. $3,050,000 and keep going up every year unless the law gets changed again. That actually was in the original lead agency statute, but people kind of ignored it, and then when they did the math, it turned into like 2 million and 5 million or something crazy. And people, oh, you can't do that. So they put it back to 1 and 3 and started at 5% cost over. Because that's the way I understood it. Fiscal penalties allowable for DCF to enact on a CDC not meeting contract requirements. CDC can request a waiver if the policies that we're required to comply with create inefficiencies or inhibit performance. Others in discussion. Consultation with dependency judges in the circuit to assess performance of the lead agency in the annual monitoring. Guess who I'm going to be visiting regularly. DCF to develop a dispute resolution process between legal staff. I talked about that already. And let's see, the results-oriented accountability system. There's 20 pages in the bill on this, so if you want to get down on the weeds of that, they are serious about looking at the child welfare system, having somebody that's neutral do an assessment and say, what are we doing to track accountability? What are we going to do to change this? They want to report on what you're doing to develop that system by February 2015. So you got some time to figure it out, but then they want to know what you do with this. And then, let's see, visual report card for the state and each CBC. Not to rank or compare performance, I can tell you that the CBCs still turn right around as soon as they get that spreadsheet and rank them. So, real cute, because that's what people do. Oh, we're third in this, we're second in this, even though we changed it and we're going to come out. Made transparent to the public and reported annually to the governor and the legislature. And then finally, the FSU College of Social Work is going to get $1 million to create the Florida Institute for Child Welfare. To do a advance the performance of child protection and child welfare services through research, policy analysis, evaluation, and leadership development. So another group looking at the whole child welfare system and giving recommendations on how it should be made better. Okay. I'll go back to my question at the very beginning. What in there is going to keep kids from dying? Nothing? What about the safety planning? I think safety planning is a huge thing, and Pat, help me. Since we required back in November that you could not close an investigation with an open safety plan, have child deaths involving DCF active openly not dropped precipitously?
Actually, we are looking at that now. We've got about 2,600 new safety plans that are new. Hesitate to say that.
Right.
That is the.
As we're being recorded, it's on video. I think you're going to see over a year to 18 months that simply because of that, cases where kids died while the CPI was actually involved in the case are going to go way down, even if it's just not a court case in case management. Yes?
It's that and the rapid safety feedback.
Rapid safety feedback has been huge.
You know, during 30 days of investigation, it's leading to different behaviors on cases.
Was the rapid safety feedback in the statute? I didn't see that in there.
No, it's not.
No.
We are teaming with CDCs and
I looked at what we're doing at the partnership for the rapid safety feedback. It's pretty good. I think we can make it better, but I was surprised. And we've been doing it for a while. We're catching some stuff, so it's a good thing. Okay, 2 minutes early. Anybody have any questions? Getting on the slide. I didn't get this far. Questions? Good timing. Mary Kay?
No questions, but before you leave, or you can put it anytime, but please don't forget to fill out the survey on your app. So you can get kudos and comments.
Let me just say, if you read nothing, read Senate Bill 1666. And get kids appointed attorneys when they fit those criteria. Have a good conference.